party started boasting that it will be in power for 60 years, and that this is the governing party, this is the party of the current president, and so on and so forth. So it's been settled. So they generate a kind of situation in which contestants and participants who ordinarily would have wished to go to other platforms and thereby not put the system, the judiciary, under severe pressure like this, we don't want to do so, believing that once they are off that platform that can win election and capture power, then their chances of capturing power will no longer be there. I think that once the political process becomes more credible, more secure from this kind of vicious and invidious control, and people, including people who may not be so moneyed, can participate in the political process as they have the right to do, and they can then tell themselves that I can win election. So there will be no struggle, this mortal combat to just capture a platform in order to get to a gubernatorial seat. And I think that once that is done, the judiciary will be on holidays. Now what they do, and this is very significant, just so that deadlines may be beaten. You see judges, taking a decision first and writing the reasons for the decision later, so that even if in the course of research their conclusion, leads them somewhere else than what they've decided, they are caught. They can no longer do that. That's not the best way to approach justice delivery. You are supposed as a judge to provide your reasoning for a judgment, and then at the tail end, that's what it is. The court hereby adjudged as follows. But when the court adjudges first and provide the reasons later, there are certain pitfalls, and it's not good for the judiciary and our justice delivery system.
You talked about the role of the judges. Let's talk about the role of the lawyers, because the case has again shown the lengths that some lawyers can go to manipulate the legal system. What can be done to check this in future?
The roles lawyers are playing right now in the electoral process is negative. It's not progressive. And lawyers will need, acting through their association like Nigeria Bar Association, will need to talk to themselves. Yes, under the Constitution, and I'm talking about Section 6(b), every Nigerian has a right to approach the court. Yes, there is access to justice, but there is responsibility, including a professional responsibility, in accessing justice. You just don't go to court because you have access. And so I think that all these political cases, and I'm speaking broadly now, have become the kind of professional mainstay for some lawyers, particularly senior lawyers. And so it's like the only way or the only area where they have expertise now is these election matters and political cases. And so when you do that, there is a kind of goading, a kind of instigation, a kind of motivation that propels them to go to court at all times, every season. Election is coming. Now this is our time to go to court. And so when you have that kind of mindset, you are doing serious damage to the judiciary, because that's not what the judiciary is meant for. Mind Nigerians, and Nigerians should know this, the judiciary is not just there to decide the cases of all these politicians. The ordinary Nigerians who have rights to also, use the judiciary to secure justice for themselves, have cases that are languishing there. And when these cases with deadlines come, all those cases are brushed aside. And these judges only have the time they have on their hands to do the job. So those cases suffer. And for me, lawyers who are playing this kind of roles, must be able to check themselves and say, this is not the way to go. So in other words, I've talked about the political process that has to, the electoral process that has to be reformed in such a way that there's a level playing field. So once the level playing there's a level playing field, and people can be confident that I can sell my personality and my integrity to win election, irrespective of platform. I think that this kind of struggle, to just man the platform of any political party that is seen to be the party that is likely to win election will be reduced.
Talking about the calls for the postponement of the elections in some quarters, is there any way or anything envisaged by the law under which circumstances the elections could have been postponed?
The law does not support a postponement. Common sense may support it, particularly because this INEC has shown that it has the appetite for staggering and postponing election. It did so in Ondo State, it did so in Bayelsa, it's been doing so everywhere. Even for a one-off election in Kogi State, it couldn't do it under wrap, it postponed it. So, and politicians may then say, particularly those who seem to be holding the wrong side of the stick now, may be agitated and be arguing, what is good for the sauce should be good for the gander. So if you did it elsewhere, why can't you do it in Ondo State? But as far as the law is concerned, I'm referring to the provision of the Electoral Act that provides for postponing of election. Elections are postponed on the basis of cogent and verifiable reasons or grounds. In a case of natural disaster or an emergency, ahead of that election. The last time I checked, self-inflicted injury of internal party strife or intra-party struggle is not a cogent and verifiable reasons for postponing an election. So moving forward, I will recommend and advocate that Nigeria revisit the two-tier election petition and election matters related adjudicatory system, so that all the appeal will end at the Court of Appeal.